Baba Tami. Kaji. Okay, okay, Kaji.
States that from the Nigeria and the rest of the country is associated to Nigeria and state of Nigeria. But so very, in fact, very likely this committed international education. Then I ask the question, if a child on this level to be not criminally liable for any offense committed within the state of Nigeria, what's the knowledge that she still incapable of making sure that pertains to avoiding the economy? My next question is number. The thing that can be and prohibited and surely in our way to secure abortion without abusing the singer and also the salvation on the decision as not my messages just because of stigma and also that's not intervention of our rights as a person with disability as a which was neglected and disregarded. Therefore, the decision of wisdom to secure or to protect the soil's right, the decision to protect the right of another person's disabilities within the state of Nigeria to avoid for further discrimination by the state of Nigeria in this instance case. Prayer by submitting or previous control of Africa. On the condition on the issue 5, this was very different, which means the question of whether the argument of the state of Nigeria and higher education violates any education bill or by international. It is clear that the provision in Article 26 of the United Convention on Law of Justice that states are bound and obligated under the law to follow through with any international treaty or international convention that law obligation to in this instance case. This has also been affirmed in a number of cases. Hence, it is clear that from paragraph 2 of the fact of this case, checking it, the state of Nigeria has ratified quite a number of international conventions and therefore treaties, and therefore they are obligated to follow through with these provisions and these particular treaties in the international space. Yes. Clearly, it's provided in Article 13 of the International Covenant on Economic, Social, and Cultural Rights that such of education must be protected. And also, it's further espoused by Article 17 of the African Charter of Human Rights, which of course is domesticated by the state of Nigeria, satisfying the condition made out of Section 12 of the Presidential Constitution. Under the political provision Article 17 states clearly that the right of education shall be protected. This has also been espoused and further determined by the African Commission on Human Rights in their interpretative mandate as structured by the African Charter. This states clearly principles and guidelines ensuring the protection of the social and cultural rights. One is this particularly paragraph 29 that the right to education under African Charter contains the right to tertiary education. Therefore, this states Ghana's right to tertiary education, which has been violated, is also the violation of the obligation made by the state of Nigeria to international obligation and international obligation ratified and investigated the African Charter in this case. A key also refers system and graduate and state of Nigeria, although it's an economically important nation. However, as the content is really canvas document on issue 1 that this structure progress in the election shall not excuse them from their duty to protect the right of Daniel in this case. Highlights. The General Convention of the Committee on the Economic and Social Cultural Rights, which is the interpretative body for the International Covenant on Economic and Social Rights, which is state of Nigeria and signed to and ratified this case, states clearly that those of progress in the election will only be fulfilled when the state is taking conscious steps with time frames to actualize the cultural rights. That's why there's progressive bill. This case, after the fact, to begin to blame, there is no progressive stated. The state of Nigeria have made conscious efforts for any time frame method to be able to actualize this right to share education. Therefore, it cannot avoid them under the provision of the law. We have a solution to this matter, state of Nigeria violate the obligation and that are going to provide partial education to primary regulations, while the children far from cities. The labor system intervention takes regulations. All parents explicitly stated by the popular street, every political services. It's the as well, in the case of the city, commission of the regulation to combat. In the case of Taliban and others, a judgment given on 28 January 2009, and in the case of Cabinet Mohammed Jami and others in Bulgaria, a judgment given by this Federal in 10th November 2020. Particularly, there are advanced of that judgment. Because stated clearly, I also direct some comments that while the court federal statute does not provide for any specific remedy and cost of the grant, these are that they are stating by the court that interventions may include declarations and mandatory orders as declarations sought to be expressly given by the party sought by the party in this case. The clear result of the government to solve declaration or to seek into the court. And furthermore, attached to that, we seek for certain mandatory injunctions and legal damages to grant by the evidence. Habitat as well, beautiful. In the case area cited, we found that another and
like human collaboration general comments. Could you please explain to the court what the status of these legal instruments are? Against part of the applicable participants. Thank you very much. Before we proceed, I found a second question. And between coming out and said, first salvation and different group which were carrying out and able to parents. And indeed, the first salvation was carried out by parents who are not the proper responsibility. That is the legal responsibility of the state with regard to this salvation. Thank you very much. And first question has to do with whether the social fighter and consumer educator are then what we say to be asked for you and to the money for support from the because this is ready to set the right to draw the activity of the national justice practice, which is the equals, which is the some of the national, which includes one, national general government to sustain policy, national student convention, and national of national as well as which is as adopted questions with the intervention and before can draw information from international treaties and make decisions of other international But in countries like federal government, those who expand and exercise like this laws and instead of just pushing them, I feel like continue at this stage. I'm not going to be thinking of the budget that they're making. I started getting it, which is appears to never something or still start the student. I wasn't scared of the last years. But the care, every person education under international, under national university, and the people, here comes one of the practical data institutions. You let down to the state education under international law to community that protect that concept, also the to protect, to keep, and promote the national rights. Therefore, the state institutions have the obligation to promote the rights of all persons protection and distribution of the country. Therefore, a student is to protect another persons, even persons with disabilities, must to valuation of the education provided in the online international law. That's why, international treaties, international treaties, states, different states, that it requires state parties to follow and not especially for individuals. Since state parties are citizens under international law. Therefore, this question, many questions are that the state of the law has obligations under international law to protect the right of persons such as the right of fair heritage, particularly children's special care, and to fulfill so paragraph B of the Maritime Constitution, which is basically Africa in Africa, because to the advantage of that, and not business, we want to be made in Africa. That would come to tell you, I tell Article 14, paragraph 2, so paragraph B, that state parties shall ensure the protection of the people, notice that the women, which includes their right to have abortion in time to avoid sexual assault. That is the exoneration of that particular law. It's going to mean that the state of Nigeria, not the person in the notice rights, and even the right body autonomy and Nigeria entity, valid application in Article 14, paragraph 2, so paragraph B, and medical under his law of education in these countries. All education of the students. Thank you so much. Thank you so much. And we will now move to the respondent on the presentation of the case. We have the and then before we we still keep the question of the facts. No, before we start, the idea of this is the foundation, which is a vertical under and a statement of the responsibility of making the application on behalf of the other person affected here. The respondent is the state of Israel. That's the members of the African Union, the ECOWAS, as well as the United Nations, and the city, all relevant treaties are protocols. But this nation has failed to accommodate this and value in terms of providing accommodation and also in terms of census. Furthermore, this one is a 12-year-old child with mobility limitations that has been reduced education in a school of choice in Nigeria, specifically in the city of Bangladesh. And this refusal was also extended when she moved to a different country, the state of Delaware, where she was further denied entry as well as the parents for reasons of not having international passports against their passport for movement. Now, we further move to Ghana, with an 18-year-old child and a student of the University of London, who has also been attempted to be withdrawn for reasons of reading disabilities, which denies him the ability to read for long periods of time. My Lord, we then need to stop this, which can be found in our part and in standards. My Lord, this action filed on the 13th day of March 2025 reflects the following issues for examination. The first being the right of expression of culture and identity, whether such rights have been violated, whether the rights of visceral and claimants to free movement have been violated, whether the exclusion of visceral and data and other disabled persons at large have been violated, considering the Census Act, whether the son of abortion against visceral is a violation of our rights, and whether the argument of Nigeria on higher education is a violation of rights. A structure of the procedure for the is simply that the applicant filed the application on merit on or before the 30th day of March 2025 and have filed no further provisional measures. My Lord, with the kind of provisional report, we still want to move to our agreement on jurisdiction analysis. Most guidance. My Lord, well, page 10 for our requirements. My Lord, as to jurisdiction, the respondents have no objection. Rather commend the great work of our legal agents. My Lord, however, as to administrative, this court, as found in the case of Kuku and others versus the report of citation duly provided on page 10, that the applicability of the ECOWAS court is divided into four rationale: rationale temporis, rationale material, rationale relative, and rationale personal. All of these form the right of the court to admit the case. And all of it can be found under Article 10 of the ECOWAS report. Not just Article 10, Article 10 of the ECOWAS report. My Lord, Article temporis, we have no objection because indeed the application of temporis is well. My Lord, however, as to paraphernalia and relations, we refer to paragraph 6.2.3 of our arguments. It states that the ECOWAS court has amended permits the ECOWAS court to hear matters from topic bodies when they are suing in representative capacity and for persons themselves of violated, following the two personnel cases. And this can be demonstrated by the decision of this court in Osadera versus ECOWAS Council of Ministers and Others, citation duty provided by them. In this case, however, the applicant is neither a victim of the violation nor has shown himself at any point of time to be a victim. My Lord, the particular report of this of Dr. Osadera as ECOWAS Council duty provided on page 10. And we think also report to read paragraph 33 of the judgment specified. Very well, my Lord, your learned brothers have stated that in order for an application seeking to contest the legality of an act to be done, to be deemed admissible, it is not sufficient for an act in question to affect the applicant in whatsoever manner that it will be. There should exist an additional condition, a sufficient direct relationship between the cause and event in simple form, and to make it easier without making that absolute question. For the interest of judicial economy, we want it to become clear that any NGO, any corporate body that files an action should have some sort of personal or some sort of indirect damage to be suffered. In this case, the Economic Commission has not proven any form of damage. In fact, the government has proven that the other person is being informed and members of their constitution. My Lord, in this case, we submit unadvertised, unrepentantly that personal and risks have been duly fixed, my Lord. My Lord, as to rational material, we rely on paragraph 6.25. In agreement with our fellow Muslims, that indeed, when it comes to violation of human rights, the ECOWAS court has jurisdiction. Nonetheless, it is settled by its report in the case of Dr. Jerry versus Nigeria, citation will be provided on page 11. That the appealing power appealing against the decision of national courts of member states does not form a part of the powers of this report. And this report cannot sit as an appellate court. What then constitutes an appellate court? 11 brothers and again one brother. In the case of Abiola and others, for the government of Nigeria, citation again will be provided. They have explained that the court will be acting as an appellate court of another national court when it's direct or indirectly rehear the national court decision to alter or to replace the decision by interpreting or applying the relevant international law. Simply what the brothers are saying is that when the matter with substance is brought from national court, with the same substance brought before the international court, that implicitly refers to rejecting the matter and an attempt to alter the decision of the national court. So it's the court will never do. And you never do that is obvious. My Lord, again, it must be we rely on the case of standards to mark versus Nigeria, citation being provided. And we still go to read the particular paragraph in question, being paragraph 13 of the dictionary. Most goes to my Lord. My Lord, the court recalls that in a similar case for human rights violation, where the US better was right of me, as defense to it was held that such an argument can only hold if it is established that the case brought before is essentially the same as another. And when such is essentially the same as another, the court is satisfied that it does not have the ability to admit such case the national court. And that simply means that when the substance of the case from national court, just to reiterate, that when the substance of the case from national court is exactly the same, only substantially the same, it does have no jurisdiction. My Lord, moving further, we rely to paragraph 6.2% of our agreement, particularly in reference to Article 7 of the Equal Protocol on Criminals. This protocol has formed the substance and has formed one possible substance to be permitted of their arguments and of the arguments and of the case discussion report, as I stated earlier in our summary in our brief of the case. However, Article 7 specifically provides that there must be some sort of direct agreement to settle the matter. Now let's break it down for others with value as well to understand. What we are saying is that there must be some other form of negotiation, arbitration, or mediation before we bring the matter to the court. That can also be called a pre-action protocol, or something that happens a precondition before we talk against it. However, in this very moment, my Lord, if you think at this very moment, there has been no one an attempt to negotiate, arbitrate, mediate, or any other form of reconstitution. My Lord, with this being said, it's still very simple to my co-agent, to the rate of issue 1 and 3 matters. Most
and on issue 1, as to whether the right to education of Mr. and Daniel have been violated. Before the coming court, we the counsel for the applicants, we the counsel for the respondents, submit that there has been no violation whatsoever as to their right to education. And my Lord, we seek to further upgrade these other 5 categories. My Lord, on the Constitution, I think does not provide for a right to education. Additionally, assuming the first concede that the right to education. When it is clear that it has been set in that law that section 660 makes such right non-justiciable, non-enforceable, and not discriminated. And my list of appeal by the learned brothers in the case of age processing federation, segregation really divided by page 12. Additionally, we submit to the summary report that the law is strike that individuals in sexual individuals is saying that no such right exists. That we submit to the summary report that the question of violation is dead on arrival, and no such right exists in the first place. Moving forward, under other rights of fulfilling obligation, and we submit to the summary report that Article 17 of the HAAG helps us understand and provide for our rights to education. However, it's mainly recognized as a freedom for applicants. Also, we submit that unlike several other articles as provided in the HAAG, which ascribe the duty to the right being granted, Article 17 does not provide. However, it grants and it mandates the state and it puts an activity to ensure, to promote and to protect the morals and traditions and recreational values recognized by the community. And that this is for me, is a norm in the state of Nigeria that medical students are able to reach for a rural study program. Usually, standard of care required by them and it is my own something that the action of the university of Mori, we are not to violate we are not to violate the right of education of Busara and Daniel, but instead, as an action of public necessity, we are not to submit that the law is clear, the law is settled, and the law is right, that necessitas and public are major S for private. It's saying that public necessity must definitely override private necessity. And this, my Lord, the action of the University of Mori, there is the importance of their duty to promote and to protect the traditional values and norms of the state of Georgia. When I submit to this report, that there was no violation whatsoever of their right to education. Additionally, my Lord, under other available alternatives, my Lord, we submit that we acknowledge and admit Article 21 of the CRPH, which mandates inclusive education, reasonable accommodation, and of prevention on the part of the state of Ogun, which includes or prevent Bisora and Daniel from seeking education outside the public school. And we submit that there exist other educational institutions which provide for persons with disabilities. And my lord, it is clear that Daniel's education up to the stage of university level, as he has definitely and will definitely passed through secondary school education, is a clear display that the state of Nigeria has indeed provided education to disabled persons. My lord, and we submit that there have been no violation of their right to education. Additionally, my lord, on the principle of inconsistency, my lord, your learned brothers, in the case of AG versus AG and federations, additionally provided, my lord, and your learned brothers in the case of Donald, Morenishe, and two others, versus the Lagos State House of Assembly.
And two one people.
Citation 2003 and 2 that the rights granted that the rights provided for in Article 2 are not justiciable and unenforceable and not to be litigated upon at any instant. May not we go further to submit that these rights are not subject to litigation. Hence, my lord, the articles that provide that give these rights the rights to be litigated upon are, my lord, clear and set that these articles are inconsistent with the Constitution. My lord, by virtue of Article 12, which gives this article by virtue of domestication, is the effect of validity. My lord, it is very clear that these articles are still subject to the Constitution. And by virtue of article, by virtue of section 1 makes them non and void, my lord, as they are inconsistent with the provisions of the Constitution. Additionally, my lord, the law is settled, the law is strict, and the law is clear that never that God will not have it. A man cannot give what he does not have. And my lord, the submission to this, we submit that the economic status of the state of Nigeria, as seen in paragraph 3.2 of the highlight of the summary that makes us understand that Nigeria is an economically poor state. Economically poor. And we submit that this can be a reason, and these are part of the reasons why the economic, social, and civil rights are only objectives for the state of Nigeria. And it is then settled at law that the actions of the state of Nigeria were not to discriminate against Daniel and Bisora, were not to violate their rights to education, but were instead, my lord, gives the economic resources which were not available at the time. Additionally, my lord, we submit that assuming does not consider that this particular right indeed exists, the law is strict and the law is settled. That let's not commit at the possibility, rather the potential excuse as legend. He's saying that the law does not command the impossibility, and the possibility excuses the law. Cannot be something that we do not intend to excuse or evade our liability of providing the right to education. But instead, these education were only objectives of the state of Nigeria, and even as to the articles which give them the right to education are inconsistent with the Constitution. Furthermore, we submit that as to the Child Rights Act and the Education Act, accepted by our learning my documents and the applicants for applicants, we submit that they do not exist and they are not recognized by the state of Nigeria. And the only laws which are likely to that of the state of Nigeria are the Constitution of the Federal Republic of Nigeria and the Census Act of 2024. Well, hence, we submit that the same Nigerian court held in the case of Kenya Limited, even that do not exist cannot be applied to government. Hence, we submit that this on the path to additionally, we submit that the actions of the state of Nigeria were not to violate and were not to discriminate against disabled persons, including Bisora and Daniel. We submit that and we seek that this honorable court declare justice by declaring that there was no violation as to their right to education. If my love will go further clarity, I would love to move to issue 2 minutes. Most grateful, madam. Now, on the second issue, as to whether the rights of children and parents to free movement within the ECOWAS have been violated. Now, on this legal issue, we recognize and we admit the existence of the right to free movement within ECOWAS, of the right to free movement of the citizens of the member states within ECOWAS. Hello, we also submit and we also assent to the signing and the ratification of this ECOWAS protocols. Hello, and we are in full awareness of the reservation and of the exemption given to member states by provision of Article 4 of the ECOWAS protocol related to free movement of persons, residents, and establishments, which ought to understand that member states can indeed restrict and refuse entry to citizens who they deem as inadmissible immigrants, my lord, inadmissible immigrants under their laws. And my lord, to this exception, the state of Africa has indeed sprung up and passed the anti-Roger admission laws. Now, my lord, this is not in any way to discriminate against citizens of Roger, but instead to put in place certain requirements which must be met before they are granted entry into the state of Roger. My lord, moving forward under the category of incomplete documentation, my lord, the law is strict that he who comes to equity must come with clean hands. Impurus, maribus, acidas pure. He who comes to equity must have no fault. He who comes to equity must be blameless. And he who comes to equity and he who seeks justice must fulfill all that is required of him on his part. My lord, on this we submit that Article 3 sub 1 of the same ECOWAS protocol, which grants upon ECOWAS citizens the right to free movement, also provides that any citizen of the community entering into the territory of other member states must be and must possess the valid travel document and international health certificate. My lord, on this we submit as contrary to this provision, as seen in paragraph 3.6, the children and parents were only in possession of the ECOWAS travel document, and they are not in possession of the international certificate as required of them by the same ECOWAS protocol. Furthermore, my lord, we submit as to the principle of necessity that assuming was not conceived, that there was indeed a violation of their right to movement. My lord, we submit that on the part of the government assuming the government of considering that there was a violation of their right to movement on the part of the education authorities as to the government of Canada. Now we submit that the defense of necessity will indeed suffice as the law is clear, the law is tried, and the law is settled that necessity has not have it, especially in situations where greater harm is being prevented. And my lord, in this case we submit that it is clear as to the summary paragraph 3.6 of the summary agreement that the citizens of Nigeria often violate their laws, my lord, often violate the obligations of the state of Canada. And my lord, it is clear and it can be agreed upon that a man cannot be held in violation of a particular right when he is in turn protecting his own person or protecting the lives and properties of his own citizens. As my lord, this relates to the principle of self-defense. Furthermore, my lord, we submit that the actions of the state of Canada, we are taking with extreme caution so as to prevent any further harm, my lord. Further harm as citizens of Nigeria indeed violate and flaunt their obligations. Hence, my lord, we submit and we seek that the state of Canada should be absolved of every liability on the grounds of preventing or causing harm. Since it is tried, my lord, and it is settled that abundance criteria none of it, abundance or extreme caution does no harm, my lord. If my lord needs no further clarity, I would love to move on to most of my lord. And on the last, on the issue 3, as to whether the exclusion of individuals with disability, such as this one done from the census, violates their right to other program concern under the CRPD. My lord, we submit on this fundamental issue that there was no violation whatsoever as to their right as to their right other program concern under the CRPD. My lord, we admit and we assert that the United States Supreme Court, in the case of Trump versus Europe, also understand that being counted in the census is a sacrosanct and civil and political right. However, my lord, discrimination in this instance may be derived from the second edition of the Black Law Official to mean denial of privileges to a certain class of people for certain reasons, and in this case, it may be seen as handicapped or disability. However, my lord, we submit that there was no discrimination then in compliance to section 6 sub 1 sub J of the Census Act, which requires the Commission to do all that is ordinarily necessary, desirable, expedient, supplementary, or incidental to the Census Council upon which the Commission said to conduct a separate census for persons with disabilities with adequate facilities so as to tend to cater to their personal also submit that this particular provision of the Census Act says that the Commission will do all that is necessary to ensure the counting of the census. Now, all that is necessary gives the Commission the right to do things in their discretion. And on this matter, the Commission considered persons with disability as persons like this who have mobility limitations may not be able to move to the place of census. Yes, my lord, we put into consideration the mobility limitations and we put into consideration manpower for all transportation as the options have taken reasonable steps and have indeed conducted a census to cater to their peculiarities, madam. And this is not wrong. This is not wrong. We go back and we to that one of the CRP, which places and mandate states to conduct special statistical analysis on disabled persons, some of the related purposes to cater to their peculiarities. But the sense of is not a resolution, it's not a commission, but was instead an act of the commission to include them in a separate census, and it was in no term and under the foundation to their right of public participation as submitted by the constitutional amendments. Additionally, I submit to this committee that justicial not pertain sacrum veritas specta justitia. And we believe that the law is clear, the law is right, that justice knows no other. Neither does it kill the father, but to cause the truth alone. And my lord, in this instance, we submit that the truth remains that there was no discrimination or violation of their right to education. There was no violation as their right to community. And there was any violation as to their rights to public participation. And this is I don't think the further clarity. I would love to defer to my co-counsel.
The first condition, which is where there's another reason, is a violation in case of person, citation of error, helps us understand several things. But I'm not sure it's something to every part, something to be and expect. Which is also be expected spiritual. Spiritual has been lacking collection of the child. However, it must be noted that it is actually to help the child. It's actually to help the child.
Understand that children are not starting from making certain
This is why understand that children are not starting from making certain decisions. And then the next thing and the next one, the parents to start make decisions such is indeed a child. It's a child. Not ends. Not the CRC. Is that when there is a child takes less and we give and this guidance was coming to society specific on a particular matter, specific was the physical condition. In this case, that so the body is therapeutic. Provide and children all general human beings. The main chapter of their which is easy to be years. However, you can find is that more that you can't said that one person with disability, yes, of ASD whether the argument is violates any laws. Two things are opposite. Two things are. The first one is that this one has non-conduct of higher education. Is a matter of choice, but in a matter of consequence, as we see in paragraph 3.2 of the agreement superior act, which helps us understand that most persons in this country of origin, in this state of origin, are unable to get that. In fact, they are able to get that. Yes, it's not a matter of information. It's a matter of honesty. But especially as we come to the KCSE, that should be realization as much as the in this instance, that the country is special but in this instance and to this extent, the national attempt such right on a progressive of the ICS, only at condition one the ICS. We are only obligated to provide as much as possible, as much as can, and not to and not to provide what we don't have, or to provide what we don't have. Because the law is that let's understand the person. And in this case, it is fair, it is just, it is right. And since we are not going to that the company it is only right that there is something the fact that the delegates at this point in the university and has been disabilities since he was born, which means that delegate has been going through secondary school. That helps us conclude one thing in particular, that there are special schools for persons living with disabilities. So the country of Nigeria has provided special schools for persons living with disability. What then is unfair? What is unjust? What is your right? Is to believe that the game that not provide themselves should provide such facilities in all the schools, and not the fact so that when you have not refused other children entry, and have not refused these children entry into special schools, what has not happened is that the particular school is unable to provide these facilities. So it is just, it is fair, it is right again to repeat that Nigeria is not strongly liable for this. Now, Lord, on the second level of our argument, the case of Sarah versus Nigeria, as well as Article 28 of the CRC, okay, that generally acceptable norm is universal basic education. Now, this universal basic education leads us back to Article 172 of the ICSL, which helps us understand the whole thing in particular. States are to provide as much as possible, as much as species, and as much as they are capable of. In this instance, it's again opposite to rely on the admission of both parties that Nigeria cannot, is incapable of actually failing for its citizens. Therefore, they should not be liable, especially when paragraph Article 28 of the Child Rights of the CRC explains and is opposite that all children are to be given the general standard, which is the universal basic education. However, and conclusively on this particular issue, it is clear, it is opposite, that justice must not only be done, justice must be seen to manifestly have been done. The issues before us not only show the tendencies of the country, not only show the tendencies of the continent,
but show peculiarities amongst persons, amongst continents, and amongst countries. In this instance, certain things will be considered because the court is not just the court of law, the court is the court of law, justice, and fact. In this instance, we rely on the Nigerian contribution by the applicant in remembering the position of them of GSC as the them in case of the July version of 1985, in making it clear that justice when referring to public settings is not a one-way traffic. It is rarely a two-way traffic. It is indeed a three-way traffic. Justice for the applicants in this instance, justice for the respondents, and justice, my lord, for the people of ECOWAS. The people of ECOWAS expect this court to examine certain factors, the facts, the justice in play, and also the laws. The laws are clear, the laws are just, and the laws are clear, and the laws are being brought forth to the court to see. Not just an aspect of the law, but the laws in some way. Now let's, in being that the case, we move on to page 20 of our list to argue the violation of the law. Most basic law. Now, although there is no ECOWAS court statute that provides for the violations, and it is indeed the position of the United Brothers in Cabinet and America, citation being provided on page 20. It is, however, clear that the court in this same case has adopted the position of the RCCG that when there is a violation of human rights, when a person or certain person's rights have been breached, it is apposite, it is necessary, and it is just to ensure that the violations are given to such persons. Therefore, such violations could be in form of order of damages to compensate every inappropriate action, as was in the case of Mohammed El University, citation also provided. It could also be in form of prescriptive order for an action, for a cause of action, as well as the Godwin Roper and others, as well as the ECOWAS heads of state and government. Citation also provided. What cannot be is for the court to give remedies without proportionality. Because your learned brothers are already the same cabinet and other persons like you. That it is important, it is fair, it is right to ensure the mutandis principle and the quantum merit principle that the others will only be granted when they are merited and only when they are proportional. Hence, moving to page 21, we see that the court orders a rejection of this matter or such orders as put forth in paragraph B. Most based on without going for respondent.
There are 7 minutes left. It will be better. But that notwithstanding, there is question for you for questions for you from another question that. Thank you so much, Leonard Council. In your arguments about the right to education, we have argued about it not being justiciable because of the provisions of your constitution. Leonard Council, I don't know if you are aware of the decision of this court in the case of Sarah against Federal Republic of Nigeria and the status of the right to education before this court.
My lord, we have considered this argument as well, so we are aware of it.
Okay, if that is the case, are you sticking to your and I have another question after that. Are you sticking to your arguments about the non-justiciability of the right to education before this court, especially considering that that is part of your international obligations which your local laws cannot override? Second question before you answer. You are here on behalf of the Republic of Nigeria, and certain persons were denied entry into the state of Yemen. But here you have canvassed a lot of arguments on behalf of the Republic of Yemen. Who exactly are you representing there? Can you explain that to the court?
The ECOWAS was formed for several reasons, but the most important is to unite West Africa. In this instance, Yemen is not just the and the fact which also puts the in this instance, especially we are assured that all parties are truly and well situated, especially a judgment against them may affect their economic condition, which may also affect transnational relations between Yenda and Ojira. Now, we are calling the show to cater for justice and cater for the laws at hand. My Lord, as to the second, my Lord, as to the second issue, as to the first question of non-justiciability, my Lord, it is quite unfortunate that in third world countries, especially, some rights are not made or are not recognized as much as they should be. This is why the international communities have brought up conventions, have brought up treaties, which the Geneva Convention have made public and have made prior to comply. However, it is important, it is appropriate, and it is necessary in the face of justice to examine the fact that the country system has made sure that in its subjects it does not recognize and justify human rights. Nonetheless, we again remind we get put about the to our page 12. The line again on the case of aside in another case of about an example, in understanding that truly and very the constitution does not make justice. However, there is a leeway, there is an alternative rather. The problem is international law. Because in this instance, the court has graded the laws that are applicable to it. The first in this case was the constitution, second was international law, and third were national laws. However, the court explained that when dealing with international relations, the international laws take supremacy. In this instance, however, and for the sake of emphasis, section 12 of this constitution ensures other continental laws to be applicable. This then empowers the court to create just as when other nations also progressive and re-enact these laws. So indeed, the question of Portugal does not justify these laws. However, the convention they have admitted makes these laws still applicable in other instances, but not directly under the constitution of the Federal Republic of Nigeria or Portugal in this instance.
Thank you so much. Now going to be better on the African Council. We have 10 minutes left out of your time.
Next, and first one of the time, the square case, and the second case, and the stand of the fact, and the active space. There are four conditions to activity. I give there are four conditions to activity. Which is that they are telling they stand of the idea. However, it can be and further this present application is remember as which is one, no analysis of the application. Two, that is access to this benefit national and two, that the applicant supposed access and application as made as the request from to learn and tolerate as if they are justices in that particular case. That's very very good. And if the students are to remember as Nigeria, learning is stated and that's not the case outside the national court. Such is an decided however, the result objectively is speak of law, and particularly, this regular also affirmation in case of Ama Adao was committed, just like the case, particularly by the 66 and 67 of the case. Don't think it. That is very happy, very happy that if the party, I believe there is no more cause for appeal. However, the case of the system is there is
practice. When you talk, they start with them like they are for research for this it is opposite. And there's a reason why this is because I'm not the medical disease and that. That's student the care of cases that the application can only be given by state parties. And not he not have any to evaluation under the law. Therefore, the only thing that should be is to provide them to the human rights of the people that the economic and medical as committed information with. Therefore, this Article 7 of the law does not allow status. And when that the law of the journal is suing the state of America to compare them to another surrender to state statutes. And the fourth kind of thing, the next that for this case, let's say it's a the position of the say, the country has also filed therefore, before this case. It's the law that establishes the that's any magazine case of search is there. The federal government of the United States as well as the active implementation. That's actually of the government before this case. So far to represent victims of human rights abuses. Therefore, it's called this NGO World Foundation as to bring the therefore, the supply of permission to apply the answers. And if you can merely they cite the permission of section 1 of the Constitution of the Republic of Nigeria to me as national convention argument for state of Nigeria. The person is surprised, especially to that particular permission. That permission is to say that international treaties and conventions are only about one that is domesticated by that particular state. We are very aware and that is the convention of African and non-Muslim domesticated by the short to as also educated better to domesticated in the year 2006. Therefore, out of education is down on state commissioner. Also, the child welfare 2009 to the United States was also has been investigated by the child welfare of the state of Nigeria to fill the commission under section 12 sub 1 of the constitution. We do not consider that this resolution, however, it is apparent to me that perhaps this is not amendment is not economic crisis for this case. Now, we say that the African Japan has been investigated very specifically notified before the state of Nigeria is domesticated. The second and second guideline, but I was not particular section 12. Article 26, international relations law treaties. So the difference that international treaties are bound by international treaties, bound by the institutional ratification. Therefore, it should be a judgment or a decision to not be seven international treaties. For the law to and foreign national court, these are not permitted to comply with the provisions of international law. And this is done as that justify their exclusion or their rejection of so another to enter of the from the permission of that the reason given for right is that the name is international elements. And therefore, they cannot be able to in this case. So it's a very important argument and the seventh number
However, in relation with the policy and economic social cultural states play greater role on the protection of state parties. That state parties shall only play a conscious effort to actually marginalize. This is they are not making conscious effort. What the question of declaration cannot have been published. Our last part of the water policy is a application of Section 6, that assists Section C of the Constitution of the Federal Republic of Nigeria. And that's an average level of constitutional law. Section 6 of 6 of the constitutional law except for the right of therefore, if there's any other replace the constitution, the expressly allows the permission of chapter 2 of the constitution. That is chapter 2 before court is stated in constitution. What is section of the constitutional statement the National Assembly is exclusively to let's say chapter 2 of the constitution. The National Assembly, even if you look at the original section 4 of the constitution, as therefore domesticated the commission of chapter and not constitution. And therefore, that means the constitution is the constitution as except as on the last part of the constitution, as the few instances, that the constitution even acquires to the National Assembly permitting them to enforce thereby the exception which are and therefore, going to this down to the this is not a bill, and contentious cannot go to what I'm doing. And because we do the law and the way, this is what say that this is the election.
That's my errors. About 6 seconds left for you to set time. That's good. We now rise for 2 minutes for us to take our decisions. Move the button.
Thank you. Let's kindly be seated. You must agree with me that it's been an interesting 1 hour. While we wait for the judges to rise, we still have some goodwill messages to take, and we are going to take them while we await for the judges. So I will call on the representative of the Onuora-Oguno Banjo Foundation to please come and take the speech. Dr. Mrs. Raji, please. Dr. Mrs. Raji, please can you come and take the goodwill message sent in by the Onuora-Oguno Banjo Foundation? Thank you.
Goodwill message from the chairman of the Onuora-Oguno Banjo Foundation to National Disability Road Sports Competition. Before I proceed, I would like to observe the protocol. Good morning, good afternoon, and Vice Chancellor, the Deputy Vice Chancellor, Academic, and all other deans here seated. I welcome you. Distinguished organizers, respected judges, esteemed participants, and valued guests, it is with great honor and heartfelt solidarity that I extend warm greetings on behalf of Onuora-Oguno Banjo Foundation to all those gathered for the National Disability Rights Month competition. This event stands as a beacon of advocacy knowledge, and inclusion. A powerful platform where future legal minds confront the reality of disability rights, compassion, intellect, and courage. In doing so, you are not merely arguing points of law, you are amplifying voices, challenging inequities, and shaping a more just society. As a charity deeply committed to promoting dignity, equity, and access for all, we applaud the initiative of this competition. It is a reminder that the law is not only a tool for justice, but also a vehicle for transformation, especially when it safeguards the rights of those too often marginalized. To the participants, may your arguments be bold, your advocacy grounded in empathy, and your learning journey continue far beyond this competition. You represent a future where human rights, particularly the rights of persons with disabilities, are upheld, not just in principle, but in practice. We wish you every success and remain partners in the ongoing pursuit of the more Lord. Thank you.
Thank you. Please put your hands together. I will call on the Voice of Disability International. You see why we have Peter, who is also ensuring an inclusive approach that the world is also seeing that of it. Dr. Bukade, please.
Thank you so much, sir. All protocol observed. I stand here on behalf of the Director, Voice of Disability Initiative, which is based in Abuja. And because of the other responsibility of the work over there, Catherine Eden, who is Catherine Eden, the Executive Director of Voice for Disability Initiative, is unfortunately absent here. Directed me to here and give a good message. Just as he has said, my name is Dr. Onuora-Oguno. I'm the focal person of the Voice of Disability Initiative in Kwara State, and it's at that capacity that I want to serve. The Voice of Disability Initiative is expressing deep appreciation to the Vice Chancellor of State University and the management team for not neglecting the rights of disabilities, people with disabilities, particularly having it in mind that University of Ilorin is an inclusive university, and that is the reason why we are able to have deaf students who are here learning in there, also in other persons with disabilities, including the and so on. The National Disability Rights Movement petition has gone a long way, which I'm privileged to be part of it. I was part of the last stage that was done about a month ago or so. So I want to really appreciate our Vice Chancellor, Professor Wahab, SAN, and the letter committee of this competition, and also the Dean of Faculty of Law for the great work we are doing. Voice of Disability Initiative was established primarily to cater for the rights of persons with disability, especially girls and women with disabilities. Their rights are protected by BDI, and not only their rights, including the rights relating to the sexual abuse that we have in the country. And that is why Voice of Disability Initiative have been moving around the country, including Kwara State. Voice of Disability Initiative are also working together with the government of Kwara State, and we are able to have issues resolved and make it particularly. We all remember that we have a law passed in Kwara State as far back as 2017. but there are still a reason to have what we call disability to have an agency to care for people with disability. And these have been what the BDI have been advocating for. We have also met other stakeholders on this. I believe that having this agency will assist us to move forward more in taking care of the rights of persons with disability in Nigeria. We want to just recognize that this disability agency has been established in other states and it has also been established in other states, just like so in Nigeria. But we believe that if Kwara State look into this agency and have Kwara State disability, disability agency, this will help us to move more and take care of the disability rights of persons with disabilities. So on this note, I want to thank you for the privilege and opportunity to be here today as voice of disability initiative which is in Nigeria. And we believe that with this collaborative efforts of the HAAG initiative, together with other people who are working on the national disability rights in University of Ilorin, Nigeria, we will be able to liberate persons with disability in the country. And that will help us to move the country forward from where it is. Thank you. God bless the country and God bless the University of Ilorin.
I also bring us great information. He sends his greetings all the way from the United States of America. In the past, the OSF Foundation giving scholarship awards to students with disability on this campus, and they are also part of this initiative. On behalf of S Nigerian chapter, I'm taking several other beautiful messages. One of the judges was supposed to take it, the financial secretary of ICON S. She's busy. We send our greetings and the design for everyone in this room, for everyone watching, is that this should continue. And the desire is that 12 to 16, 26 is going to be the third edition of the Senior Advocate of Nigeria National Disability Commission. This competition has come to stay, and we hope when we hear the good message from the ECOWAS court that we are going to sustain this, and in the near future, we get an African university from West Africa to act with the duty of these students. I want to add to the Vice Chancellor, Professor Onuora-Oguno, to speak to us first as the Vice Chancellor, and then after the awards, he will speak to us second. As I see Alaja Ole is also here. Remember that the African. Oh! Okay. That was. Apologies for that. Please be seated. The Deputy Vice Chancellor Academic, Professor G. Akande, the Provost, Professor Sulaiman, the Dean of Professor Wilson, the Dean of Arts, the Dean of S. The
this was right, it was happening, where education was also there. And of course, the first team, Professor Onuora Oguno, distinguished participants, distinguished ladies and gentlemen. Let me, on behalf of the entire management of this great university, welcome all of you to the Better by Far University. It is indeed a great pleasure to be part of this initiative. And I want to appreciate the fact that you have devoted time to be part of this process. While we are acknowledging and appreciating the first teams that make it to the semi-final rounds and the final rounds, we also want to put on record the fact that other teams have participated and over time couldn't make it to the final rounds. But as a university, we are acknowledged because if they have not participated before now, we will have a final round. Also, I want to especially the Dean of the Faculty of the Law for allowing this to happen in our regime. I know that when the idea was launched, like I told the team that they did not see the seat, I insisted basically on the fact that we have a yes, well, we are meeting it. Yes, good call. Yes, I mean good call. Yes, because it is important for us to clearly define and redefine our processes. It's so easy to forget so easily because time has a way of creating some narratives. If I were not vice chancellor, maybe, but the fact that I am sitting vice chancellor will send some wrong signals, and that was why I was different. But when I could not stop this, and there was no I moved it. I decided that I was not going to get get people to their work of my hand. But as fate to have it, yesterday, we said we have sent invitation to the provost in the part of this. I will be responsible if I now send a counter message. And I want to appreciate the organizers for giving me this. And pray that God will listen to the practice on each and every one. Disability issues is something that I am passionate about. And I guess that was when the organizers looked around that idea. I know that we wrote a proposal 10 years or more ago, and we had $80,000 to set up the dealer in our university. And now, disability. My take is that we are all actually disabled, one way or the other. There's a very thin line between ability and disability. You can be disabled at any moment. I had a personal experience. We are coming from South Africa to Ethiopia. We traveled in and I came out of the airport. In the airport, I arrived there. I slept. And for almost 6 or 8 weeks, I was sleeping. There are so many other such challenges that we have with.
For me, it is important for us to emphasize the need to take care of all of us, irrespective of our status in life. And the conclusion let me especially appreciate all the sponsors, the Onuora Foundation, DLAB, JRC, disability initiatives, and all other sponsors. We thank you, we appreciate you, and we continue to hope that the issues that we have addressed in this place today resonate with all of us. Because at the end of the day, the essence of creating issues is to call awareness to disability rights issues. I also want to specially appreciate the ECOWAS support for being part of this initiative by sending one of their representatives to be on this panel. It is my hope that this project will grow, will continue, and will continue all our attention to disability rights issues in Nigeria. Thank you so very much.
Thank you, Mr. Vice Chancellor. Um, I will need to remind Mr. Vice Chancellor that $40,000 from that $8,000 is still hanging somewhere between Central Bank. I believe that in this age and era, such an amount of money should not be lost in the air. And we call on the university to perhaps try again to reach out to the authorities, because that money brought to Nigeria and somehow we don't know where that money is. Sad enough. I would go to others. Let's take our time, take a chance while we wait for and we get the final event. I think particularly the provost, because I to him and I said the case we've seen it inspired the fact that this case, it was actually a true situation that was before the Senate of the university. And when we listened to that case, we said, let us test it and have the university will bring the police how to handle such issues in the future. So, in the next 5 minutes, just check if the judges are ready for the announcement of the results. Thank you. Yes.
we can have to see Vice Chancellor, I don't know why that was landed for senior advocates. I think to me it's the most important, but when I don't know, it's for that. However, the day of other properties, the introduce of various partners. Most honestly, I'm happy to be here. Not because of anything, but because of the excellent presentations of the applicants as well as the respondents. We have all done very well. There is no doubt about that. There is no doubt about that. This is the session, please. The arguments by the parties were excellent. The presentation, the command language, knowledge of law, and the application of the law to the fact are all the agents that are top notch. Most honestly, I must give it to all of you because some lawyers that have been called and not to do, not to act. That is just a simple truth. Why I was making your addresses at I think I was late yesterday. I was trying to plan meeting this morning. I can't but to say that this affects they are perfectly researched, perfectly presented. You all done very well. Thank you so much. And we really appreciate the giving this opportunity to us, at least to meet with him outside the court hall, since he has zoned the office. Thank you so much. For the applicants, the total score that we have here is 81.875%. And for the respondents, we are 80.5%. It was a very keen contest between the parties. In fact, we don't get to this because as a result of creating separate scores from all the finalists. With just less than 1 point, with just less than 1 point, the applicant match as a winner of the contest. And that is the announcement of the contest. The best analyst to the second agent for the applicant. For the sake of emphasis, the best price is agent 2 for the Africans. I think agent 2 is the dark man sitting, the dark council. Thank you so much. I will not hand over the microphone to my larger brother, Mr. Fabio from ECOWAS for us to make some. Thank you so much, my Lord, for giving me. Honorable Vice Chancellor, permit me to stand on the existing protocols made by my God. I bring greetings to you all from the Honorable President of the Court, Honorable Justice Ricardo Salvash, who is currently with the court sitting in the house where the court is having an external session. I also bring greetings from my director, the Director of Legal Research and Documentation, Dr. Jado, who wanted to be here, but for last minute changes in the schedule, is able to make it. And has had to send his undeserved apology to the Vice Chancellor and to you all. From what I have seen today, the future of advocacy at the airport is very bright. Super impressed. I think the aim of this competition to let students know about practice and procedure and law of the community has been achieved. The level of advocacy that is here, and I must say first as somebody who practiced before the court for a number of years and who now works for the court, is better than 80% of the lawyers that I've seen at the court. And if you were to argue to, like you did today at the court, nobody would know that you're still students of. So congratulations to you all. I understand the university administration and administration of the faculty of law for inviting the NUS court to be part of this. Coincidentally, the court itself is planning a similar competition to what we do this year. And I will take a lot of lessons back from this competition for the court to use in its own planning. So thanks to all the students and participants and all the people, students and guests who are starting to listen to this participants. I hope that all the students are also in the lesson and that you also get interested in it. Yesterday, for those who were there and even in the presence of the Honorable Vice Chancellor this morning, I mentioned that in 2005, I was equally with students like in the university to participate in the youth competition there. And in 20 years, I can see how the participation at EM has contributed so much to the career that I have today. So I encourage you all students to get involved, get interested, learn. Nothing helps you to be able to think on your feet. Become very smart when I'm hearing what you're doing. So I hope you develop interest in that. Comments I would like to make about arguments today. I would encourage learned counsel on both sides to learn about the obligations of the state with regard to the human rights. But perhaps there were special arguments in there that we didn't quite experience very well. It's a form of constitution, not to respect, to protect that. I don't want to make any comments on issues that have been litigated. Then, when you are in an international court such as this, the court is not swayed by how much English or Latin that you can cite. It's an international court. We want you to rely on your arguments on international to try and pursue the court. I hope that's the best thing. Once again, thank you all so much. Excellent advocacy. Your future is very bright. Thank you so much. Let me just progress. And I didn't brothers in the exchange together, and also as well as people having practice together. And after some years, we are meeting again. Lastly, I am privileged and I'm happy as well to share my experience as Chancellor. I'm moving next. Thank you. So we are going to go straight to the presentation of the awards, congratulations to all the schools. And now I think it's important for us to state that the identity of the schools remain anonymous until now that we are announcing their tried to mask them for a very long time. And for the preliminary rounds, the first four schools that appeared for the disciplinary was University of Nigeria, University of Guinea, Six University, and the University of Nigeria. So to start by announcing that each of these four schools have a 100,000 naira participation and the best orally also won with 100,000. For the team with the best respondent memorial, University of UNA, University of Nigeria, Suka, is the best respondent memorial. We ask our Dean of Agri to please step forward and make the presentation. Best team with the memorial. The winners of the best dance memorial, they will be presented by INC directors. Winners best applicant memorial. And for each of these rounds, immediately each round ended, the match and everything ended at that stage. So we didn't carry over. And that was won by the University of award
third best school, second runner-up. Second runner-up is of Guinea. I'm going to give this to present the first runner-up. The first runner-up is lifted. The parties I saw from this city in this competition should be eliminated. University gave them a box and took this name to bring them down to this place. After of the VC, planned by the Dean of Engineering and presiding judge for today, and Mr. Onuora-Oguno to present the award, and all the judges to present the award. To present the award to the winner, and of course, please join the vice chancellor. And of course, the host dean should also be in this presentation. Both as a host and last time had a competition here. University of Onuora-Oguno. It was the Bonny State University and Imo State University that appeared in the finals and to tell all observers that everything we do in the state is like this. Of course, you know, the vice chancellor, we stay transparent, and everything flows. So please, these two young men serve as going to be representing the university and South Africa. But I don't think this dream is coming true. I want to beg the Dean of all and the Vice Chancellor to ensure that this dream comes true. If this talent dies here, we will have done a great service. Please, let's stand up for the country. We have shown excellent independence and participation of the protocol of the Onuora-Oguno. And the winner of the business Wahab Nagawale, senior advocate of the national this margin is less than 0.5%. Congratulations. I will once again appreciate all our judges. I will once again appreciate all our judges for the preliminary rounds and thank every PI for. Okay, all the participants, please. All the participants, please go join the Vice Chancellor. Sorry. Go join the Vice Chancellor for a picture. Go with your awards. Go with your awards. Go with your awards. Let me look. Please go with your awards. From judges of giving all participants 200 students, he's giving them 5,000 naira. So I call on the Vice Chancellor to declare the event. Yes, they will snap it. We'll take pictures outside. Pictures also.
Thank you.